Welcome, welcome, welcome. Good afternoon, everybody on both coasts and everyone in between. My name is Dan Balkaran, and I am going to be your employment lawyer. There's my name on the screen. Employment lawyer for the next half an hour or so. As it says there, I'm an associate at Samfiru Tumarkin, LLP, which is Canada's lead employee side employment law firm. A couple housekeeping notes, which I'm sure will flash on the screen now. You can reach us if you need to at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, so let's get into some of your questions here. We've got a couple rolling in. Thanks everyone for doing this at a different time slot. I usually do it at 10:30 Vancouver time, but I had to adjust it today. So thanks all for joining me. I hope we get some great questions like we always do today. Okay, question from, it's a unique name, so I'm not going to say it. I'll just say a question from S. I was let go from a work from home position about a year ago. Company provided me with equipment and furniture to perform the job. When I was let go, they took back the equipment, but said to keep or dispose of the furniture. They recently called me and said they have changed their policies and need the officer back, or should I pay for them? Can they do this? It's been a year. If you have an email saying throw out the furniture, no. I mean, what are they going to do? Sue you for it? Good luck, right? So, if I was your lawyer handling this matter, I would just tell you to do nothing, right? If they're going to sue you for it, maybe, well. Now that I'm thinking about it, everybody loses if you have to get involved in a lawsuit. So, in that situation, you're probably on solid ground to say, hey, you told me to dispose of it. In fact, that's what you should do. You told me to dispose of it, and so I did. And if they sent you an email or you have it in writing where they said keep the furniture or dispose of it, just attach that email to your response, and certainly I would stress the fact that all this happened a year ago, and so you'd moved on from this. You can certainly hire a lawyer to do this for you if you want. I don't know if it's necessary. I think in this situation, I can't see them. I mean, I don't know what the value is of the furniture, but I can't see them pressing you for that furniture after they told you to, or the value of furniture after they told you to get rid of it. So I don't think that's seriously going to be a serious matter for you, but I would probably respond. The core of your question actually is not how should you respond. It was can they do that? Well, if they told you to get rid of it, you got rid of it. No, I mean it's done. So I wouldn't worry too much about it. Okay, next question. My company was recently sold and a new owner wants us to sign new contracts and go back in a probation period. If I don't sign, am I still entitled to severance? So, these questions come up a lot lately, but if the company you work for was sold to a new purchaser, if there's a distinction between whether or not it was a share purchase or an asset purchase. So if in a share purchase, the ownership of the company changes hands completely, including the assets and liabilities of the business. I mean, you as an employee are a liability because you get money every pay period. And so generally in a situation like that, your employment transfers over as usual. And so if they were to fire you at that point, you would be owed severance from the new ownership, I guess, but it's still the same company or the new company that has acquired you. However, it's not quite that simple. Sorry, and I'll say with the asset purchase, an asset purchase would be like General Electric owns a nuclear space division, a financial services division, and a few other divisions. And so every once in a while, a business like that will just say, okay, I'm selling my financial services division to somebody else. And you work for the financial services division. That is technically an asset sale. GM has not been taken over lock, stock, and barrel by new owners. In a share purchase, it's an asset sale. And that gets more complicated because in that situation, the liabilities aren't acquired. It's just the assets that are acquired. And so, does your employment continue on? And I mean, generally, no, your employment is effectively then terminated at that point, and then the new entity keeps you on. The new entity keeps you on as an employee, but you're starting from zero effectively. And then if you were to go after severance, it would be after the old company. I guess in that case, General Electric. However, what makes this a little more complicated, and apologies for such a complicated answer, is there's law in BC that says, regardless of whether or not it's an asset purchase or a share purchase, even though those distinctions certainly help the court assess your entitlement to severance, what matters is if whether or not the business was sold as a going concern. So if it was, ABC business selling widgets, and you work in accounting, and then all of a sudden you have new ownership, regardless if it's an asset purchase or a share purchase, you're still working for either ABC company or DEF company making widgets, and nothing changes, and your pay doesn't change, and all that other stuff. So in that situation, your employment sort of continues on effectively what the law has said, and therefore you have a severance claim against the new employer in the event that they terminate you. Unless, and I know it's very complicated, but unless the new employer says, we do not recognize your previous years of service, as far as we're concerned, you are a fresh new employee, in which case your action for severance, if your employment was severed at that point, is against the old employer. It's very, very complicated, and if you're thinking of moving on or not signing this new contract at the probation period and so forth, you're going to want to talk to a lawyer, and I'm going to get into that in a second. But they want you to sign new contracts, so that sort of indicates that they're not. I mean, I don't know what's in the contract, but the employment contract, but that kind of indicates that they consider you to be a new employee as of that moment. I mean, it depends what's in the wording of the contract. So if you refuse to sign it and they fire you, is your action for severance against new employer or old employer? Okay. And you're going to want to determine that. You're going to want to determine it quickly, so you can decide how you want to handle this particular situation. You need to absolutely 100% talk to an employment lawyer now. If you wish to speak to us, you can do that. You see on the screen, employmentlawyer.ca, helpandemploymentlawyer.ca, and 1-855-821-5900. I've recently done quite a bit of work on this particular topic. So if you are in BC, you can follow those what I just put on the screen, and you can reach out to me if you'd like, and I'm be happy to talk to you. But that's generally sort of the lay of the land. You need to talk to an employer right away, an employment lawyer right away, and before you sign that contract. You need to assess what your severance entitlement is, because if you have 24 months coming to you, this is a serious question, right? And you may in fact want to get what you can now going out the door. But on the other hand, if you've got 2 months of severance coming to you, maybe it just makes more sense to sign the contract and move forward with this new company. So 100% you need to talk to an employment lawyer. Okay, that's the same question. Is my employer allowed to reduce the amount of vacation time I'm granted per year for a salaried full-time position? So if you were a provincially regulated employee, and not 95% of 90 to 95% of us are, and just so you understand the distinction, a federally regulated employee would be an employee who works for a company that does matters that are interprovincial, like an interprovincial oil and gas company that has pipelines that cross different provinces, or a train company, or telephone networks, or banks, that kind of thing. But the vast majority are provincially regulated. So if you're provincially regulated, your minimum entitlements for vacation pay are located in the Employment Standards Act. You're entitled to 2 weeks pay, and or 2 weeks paid vacation, and if you've been there for longer than 5 years, then it's 3 weeks paid vacation. So they reduce your time? So you can't get it reduced below that if, again, you're provincially regulated. The 2 weeks or 3 weeks, depending on how long you've been with the company. But if you have bargained for something greater than that, if you've 4 weeks or 5 weeks or 6 weeks or whatever, if you are negotiating a new position, you're getting additional compensation, and saying, okay, well, we're going to give you a raise, but we're going to take away some vacation time. I think they can do that if you agree to that bargain, right? The question is, if you agree to it, then you're fine, right? But if you don't agree with it, can they impose it upon you is the real question. And if they impose it upon you, do you have a claim for constructive dismissal? You may. Constructive dismissal. So, just for those of you who don't regularly follow us online or watch our show, your only legal right in the event of your termination is severance. So, in order to get severance, you have to be terminated without cause. However, there's something called constructive dismissal. Constructive dismissal is where the actions of the employer are tantamount to a termination. They're effectively the same as a termination. And so there are a few ways to get there, but what we're talking about right now is that the employer imposes a unilateral change upon the terms of your employment, the fundamental terms of your employment that you don't agree with and reject. Okay, and so the classic example there would be if your pay is reduced by more than 10%, 20% kind of thing. You can't come to work and they say, well, we've just reduced your pay by 25%. Well, okay, that's a termination. It's a totally different contractual arrangement than what you had been laboring under before. Okay, or they reduce your hours and therefore your pay gets reduced by 25% or something like that. Is a reduction of your vacation, that is part of your compensation package, also a constructive termination? It depends on the circumstances, the facts, the context. Was it a massive, if you're making $30,000 a year and they reduce and you've got 5 weeks vacation, they reduce it to 4, maybe, because it's a significant part of your compensation. But if you're making $100,000 a year and you have 6 weeks vacation, they reduce it to 5. No, it's not going to be a constructive dismissal. So, I sound like a broken record today, but you're going to want to speak to an employment lawyer if this is a significant issue to you. And again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. I don't have enough information here to be able to properly assist you with this, but are you getting a raise? Is it they're giving you a raise or a promotion, or you're a salaried employee, and in exchange they're taking away a week of pay? Because a week of pay isn't nothing, right? It's whatever you get paid per day or per hour times 40 hours. That's a significant thing. So it is a reduction in your compensation, even though it doesn't always classically feel like it. So something that you'll have to hash out. If it's of importance to you, certainly talk to an employment lawyer. And if it's if you can reconcile and maybe reconcile is not the right word, but if you can resolve this amicably with your employer, that's almost always going to be the best solution in the case of your question. Okay, Katrina asks, with all the new COVID vaccination information out there, the people that lost their jobs due to not wanting a COVID jab, do they have a legal case to fight back? So it's a loaded question. We represent many clients who have lost their jobs due to violating mandatory vaccine policies. And so the question then, the question that's sort of working its way through the courts right now is, if an employer, does the employer have the right to say, all right, Katrina, you must take this brand new, unvetted, at least classically unvetted by the standards of general vaccine vetting, which is about a 10-year trial period. So these brand new unvetted vaccines medicines being, can the employer say you must take this, or if you don't take it, I can fire you and not pay you anything because you refuse to take it, right? And this question is a very complicated question. Employee side counsel has generally thought, well, it's a serious thing to say to somebody, you've got to get an injection of this new medicine into your arm, and that is effectively a new term of employment that you didn't bargain for. So the employer cannot impose it upon you without providing you with it's called fresh consideration, but fresh value for doing so. So in any agreement between two parties, fresh value has to go in both directions in order for an agreement to be valid. So if I sell you my bike for $20, we have a good bargain because bike goes one way, $20 goes the other way. But if I give you my bike and you don't give me anything, we don't have a good bargain because you didn't provide me fresh value. And so the idea is, in an employment relationship, it's an indefinite arrangement where you're trading your labor for money forever. If the employer wants to impose new terms upon you, it has to provide you with fresh value. Like, here's $1,000 signing bonus, and you agree in exchange that you will get that we have the right to require you to get vaccinated, okay, COVID vaccinated. And so, for most of these, that was the thinking initially, and then the employers started taking the position that occupational health and safety legislation across the country, Work Safe BC in British Columbia, I don't know what else it is, and I think something's called OSHA in Ontario, but it's all the same stuff, more or less. That they all those pieces of provincial legislation have sections in it that says that employers must take reasonable measures to keep their employees reasonably safe, or something to that equivalent, and that vaccine mandates, mandatory vaccine policies by employers were reasonable measures to take to meet that requirement of the legislation, the occupational health and safety legislation, to keep their employees reasonably safe. Okay, and so that changes sort of the focus from, was it a term of your employment that you agreed to or did not agree to, well, it doesn't matter if it's a term. We have to keep you safe and our employees safe, and it was a reasonable thing to do because all the doctors said we had to take. It was the best way to handle COVID, or to ameliorate the risks from COVID. And so that's the sort of the battle that's being played out right now. And there was an initial decision in British Columbia that said mandatory vaccine policies were reasonable in the context of an unpaid leave, silent on whether or not in the context of a termination. And there have been other arbitration decisions that sort of say the same thing. It's working its way through the courts. That particular British Columbia decision said something that I found to be surprising, where it said that the court assumes as fact, it's called judicial notice, but assumes as fact that COVID vaccines do not stop infection or transmission. They don't prevent infection or transmission. Okay, so that's a fact. Later on in the judgment, it then says, but mandatory vaccine policies were reasonable to keep the employees of the particular employer, in that case, safe, reasonably safe. And I don't know how those two things square up, because if they don't stop transmission, why are they a necessary thing to impose to keep employees safe? Because they don't stop transmission. So these kind of things will work their way through the Court of Appeal and probably up to the Supreme Court of Canada. So a roundabout answer, very long-winded way of saying it's being sorted out right now. What the law is so far in British Columbia is that in the context of an unpaid leave, COVID vaccination policies were valid, and therefore there's no severance claim for an employee who was put on said unpaid leave. Silent on termination. I suspect that in cases where the employer fired the employee for not getting vaccinated and didn't pay them severance, I think that they will probably be entitled to severance. I think that's the way the law seems to be moving. So, but it's still too early to know. Okay. Suzette asks, after being told I couldn't have a change to my shift, my employer has now told me that I cannot return to my position after being on maternity leave. What should I do next? I don't know what those two things have to do with each other, Suzette. You were told that you couldn't have a change to your shift, and now you're being told that you can't return to your position after being on maternity leave. So listen, Suzette, every province has, and the federal jurisdiction as well, has a human rights code or human rights legislation, and all of them say you can't be discriminated against on the basis of sex, which encompasses maternity leave. So you are entitled to return to your position, or one that is reasonably similar to your position in terms of duties and pay, for being on maternity leave. And if you do not, if your employer does not permit you to return to such position, provided that it doesn't have a really good reason, like that whole division got eliminated, or something along those lines, you absolutely have a human rights complaint. You may have a wrongful dismissal complaint as well. You have 1 year in BC to bring your human rights complaint. I don't know what it is in other locations, and then 2 years to bring a wrongful dismissal complaint. You 100% need to talk to an employment lawyer right away. Again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. I don't know. It's not clear, Suzette, from your email if they're putting you in a different position, or if they are just saying you're done, you don't have a job here anymore. If they're saying you're done, and you don't have a job anymore, you've got a little bit of time to talk to a lawyer and figure out how to go after, if that's what you want, go after severance and human rights damages for being effectively fired because you had a child. But if they just put you in a different position, then you have less time, because you have to assess whether or not the change itself, so the imposition, we talked about this earlier, but the imposition of the new position upon you is a constructive termination of your employment at law. And that's going to depend on how different it is from your old position in terms of pay, duties, etc. You need, a lawyer is going to have to assess that for you, including whether there's a point in triggering a constructive dismissal. But you only have, pardon me, you only have about 2 months after the imposition, so the unilateral change to your position, to reject that change and claim termination. After that time, you're deemed to have accepted it, and then you can't in 6 months go back and say, oh, you know what, I actually think that you fired me by imposing that new position upon me. So if you are still working there, then you need to talk to the lawyer right away, because you only got a couple months. Suzette followed up saying, you requested to move to a different shift, days instead of nights, for when I come back from my leave. I need a shift change for childcare, but they said it wasn't an option. That's a totally different thing than what you said earlier, Suzette. Listen, you would be, if you can't work evening shifts, what I would do is I would get a medical note needed for childcare. Right. Okay. That's a really tough one. I generally speaking, to get family status protection under the various human rights codes, the change needs to be imposed. Like, I take it you are always working nights, needs to be imposed by your employer. You're going to have to, that's a cutting edge question, and I don't have the answer exactly for that. Your options are, well, you can choose. I mean, it's a very, it continues to be a hot labor market. So, you can always vote with your feet and go work somewhere else. I know that's not necessarily the solution that you wanted to pursue, but it is an option that more employees are pursuing. If there's a medical reason why you can't work evening graveyards or nights, certainly a note from your doctor will probably do the trick. But that's all harder. It's a harder road to go down when you've already said you needed it for your child. I think that you need to talk to a lawyer, an employment lawyer, about this issue, but with respect to the human rights protected ground of family status, because it's very complicated because your employer didn't impose a change upon you. It got imposed by, well, it's your new requirement because you had a child, and I'm not nuanced enough. I certainly know people who are. If you want to reach out to me, and I can put you in touch with them, but at least in Ontario and British Columbia. But I'm not nuanced enough in that particular area to be able to properly answer that for you. But that is a complicated one for sure, and you're going to want to move on that quickly for the reasons that I set out earlier. So sorry, Suzette, I wish I could answer that more fully, but if you are in Ontario and BC, I can certainly direct you to the right people. Okay. And of course, you can reach me at help@employmentlawyer.ca. Danielle asks, can my employer change my job description? Well, yeah, I mean, it depends, right? Like, were you the vice president of marketing and now you're the janitor? Or is it, a nuanced change, right? And like, your employer can make changes. It's just whether or not the changes they're making are a unilateral imposition to a fundamental term of your employment, which is a de facto termination in the event that you reject those changes, right? So, if my job title tomorrow changed from associate lawyer to associate counsel, and my job description changed slightly, that's not a constructive termination of my employment. But if to use my example that I gave to you, if you went from some position like manager of customer service to I keep using the word example janitor. I mean, no disparagement to janitors, but they're radically different positions. Then yeah, that would be a constructive termination. But did your duties change in a way that they were hollowed out, or there was a loss of prestige, or did the title change itself, even if there are no duties that are changed, the title change itself entail a huge loss of prestige? These are questions that are, again, nuanced, and your remedy is if in fact you talk to a lawyer and your remedy is in fact that you do have a constructive dismissal. Sorry, if the lawyer thinks that you through these changes constructively terminated your employment. Your remedy is, you claim constructive dismissal and you go after severance, which maybe not, you might want to continue to work there. So lots of things to evaluate. Again, you got 2 months to assess it. Job descriptions aren't really anything. I mean, again, it depends on your duties themselves. And job descriptions don't often match what duties are. I mean, they do in some employers, but a lot of them, they don't. So, okay. Hope that answers your question. John asks, I've worked as a director for 8 years. They recently moved me into a new position that does not have the same opportunities for advancement and development. Do I have to accept this change? Well, this is the question. This is the session of constructive termination. So as I've said to everybody else, your employer, you're working under a contract of employment for a given employer. Okay, and the core of that is you do a certain amount of duties, defined duties, or maybe not defined, but a certain set of duties for pay across time. Okay, and that's what you're working under. If your employer wants you to move into a different position, you guys can agree to that. But if your employer, if you don't want to move to that position, your employer just imposes it upon you. Okay, if that imposition was to a fundamental term of your employment that you didn't agree with, such that your position is now significantly or radically different, and in particular, if in a way that is detrimental or hollows out your satisfaction, prestige, etc., then you might have been constructively dismissed. But your only option then, within 2 months of the change, and quite frankly, it should be sooner than that, is to, it gives you an opportunity to try on the new position. Your only option is to claim you're constructively terminated, and then you're done. You're never going to work. As soon as you do that, you're never going to work with the company again, and then it's an evaluation between lawyers. It's an evaluation between lawyers, but it's an evaluation in the legal system of whether or not that imposition was a constructive termination of your employment. And if it's not, if it was deemed that if the court deems that it wasn't, then you basically quit. You get nothing. But if it was, then you are effectively terminated, and you move on to the severance evaluation. Now, you are 100% going to have to talk to a lawyer, because it may not be worth it. If you have solid termination clauses in your employment contract, then you're not going to pull the trigger on this for 8 weeks of severance, or 5, or whatever it is. But if you have 24 months coming to you, you might, and it might be the only opportunity you have to forge an exit where you get a whole bunch of money on the way out the door, right? So you John, need to 100% talk to an employment lawyer. Again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But before you make a call on accepting or not, it's not so much accepting or not, it's rejecting or not, you need to assess what your legal entitlements are, and then you need to weigh that against sort of the practical realities of your career and your life, right? And sort of marry that all together, and then come up with a decision. So you need to talk to a lawyer. Is that it? Did we get everybody? We got everybody. That's fantastic. Those are all the questions. So thank you all for those great questions. It looks like we're out of time anyways. We're 32 minutes in. Thank you for the great questions. You're welcome, Suzette. Appreciate it. And thank you for the great questions. I wish you guys all the best. Have a wonderful and safe weekend. I will be back 2 weeks from now in my regular time slot at 10:30 a.m. on Friday, 2 weeks from now. We've got our next session. Our next Facebook Live session is coming up. There it is, Monday, October 31st, with the wonderfully named Chris Justice. He will be bringing you employment justice at 1:30 p.m. Eastern Time. So don't miss that. It will be very informative, and then you can see me again in 2 weeks. So thank you all very much. Thank you for your questions, and again, they're great questions again, and have a wonderful and safe weekend.